And I would like to give the floor to the next moderator. I can see we have the speakers already. We have Sofiya Vydra, who is the main local expert at the EU-led Pravo-Justice project on European integration, and Iuliia Kovalova, an attorney at law, IMI qualified mediator. Thank you very much for having agreed to moderate this very important session. It's going to be dedicated to consumer disputes. I mentioned yesterday how relevant this issue is for Ukraine today, because again, to refer our consumers to courts, and the courts survive difficult times. Unfortunately, there is virtually no other alternative at this moment. So please, over to you. Can't wait for you, please. Thank you so much, Louisa. I would also like to welcome everybody, those who have joined us to this last panel of the day on Friday night, but after such inspiring words and such an important information from Bruce, it is so nice to start this panel. We're waiting for very strong speakers, and this is my pleasure to moderate this panel discussion dedicated to alternative dispute resolution. And it's so nice to have such a great co-moderator as Iuliia Kovalova. Thank you very much.
Я б тоді пропонувала переходити одразу
I would suggest to move straight into the topic and start from our first speaker. Just for introduction, the first presentation will be about the legal framework of the European Union. And for us, for Ukraine, right now, the EU Aki is just super important because it is, as you may know, Ukraine is on its path towards European integration. And since June, there's an official negotiation process that was started. So the Ukrainian government agencies are getting actively ready to the second round of meetings on screening. And as part of this the screening, this is section 23. This is going to be dedicated to ADR. This is a great honor for us to welcome Margarita Tuk, who is a lawyer and the legal and policy officer in the European Commission. She is also working a lot on consumer rights protection. Hopefully, Margarita will be able to share with us some of the proposals regarding amendments to not only our legislation, but maybe European legislation as well. And Margarita is from Estonia. And when she graduated from the university, Estonia was actually in its process of accession to the European Union. According to her, her participation in such activities like today's is an opportunity to think back to the entire community for the support that has been provided to Estonia on its path to the European Union. So please, Margarita, the floor is yours.
Thank you very much, Sofiya, Iuliia, everybody, Louisa, good evening from Brussels. Thank you very much for the introduction and for having me. It's the Friday night, so I'm very impressed that you are still here and still listening to us, and we will do our best to make it worth your while. So I hope you hear me well. So I will try to share the screen. Louisa just mentioned the start of the European accession process and European integration, so congratulations on that. And the topic of our last session for today are the consumer disputes. And as Louisa mentioned a few minutes ago, the consumer disputes are sometimes or most of the time not really suitable for courts, so they do not reach the court. It's not only in Ukraine, it's not only in the EU, it's basically across the board. So again, a lot of consumer disputes are low-value disputes, and so yes, you can have a problem with a mortgage or with a car purchase, but a lot of them are really, really tiny disputes, so they are maybe not that interesting for the courts. But these small disputes, they can result in a very big damage and very big consumer detriment, and important issues for the whole functioning and for the transparency of the consumer markets. That's why the European Union actually has a policy on consumer disputes and consumer redress. So this is a part of mediation. This is a part of alternative dispute resolution, but it is not 100% the same as the general legislation on mediation. So maybe some of you have heard about the mediation directive, and here we speak about the cross-border rules. Here we speak about the principle of the voluntary nature of mediation. So for the consumer resolution of consumer disputes, the rules, the approach, the logic, the concept are a little bit different. So for us, consumer ADR is not just a mediation, but it is a redress tool. So the purpose of the European consumer ADR framework is that the consumer should have a pragmatic, affordable, effective way to obtain redress when their rights are not fulfilled, when there are infringements or there are disputes. So this is why we are not really very much prescribing. So we are not saying that it should be voluntary. We are not saying that it should be obligatory. So we look at what is happening in the member states. So the ADR directive from 2013 is a minimum harmonization directive. So the only thing we require is that the member states create a system when the consumer who has a complaint, who wants to resolve a dispute, has somewhere to go. So there should be access to a quality ADR that meets the minimum requirements of the directive. Then again, these minimum requirements, they are related to transparency, quality, effectiveness, and fairness. But we do not prescribe if it's going to be public ADR, if it's going to be private ADR. For the alternative dispute resolution entities that are funded by the traders or the trade associations, there are separate guarantees of independence to make sure that they're really unbiased. But other than that, like how you found, how a country organizes the funding on the architecture of ADR entities, consumer dispute resolution out of court, basically we respect the national choices as long as the resulting system is effective. Then again, it has to be affordable for consumers. So normally we want the ADR, consumer ADR, be for free for consumers. We understand that it is not always possible, so we are also accepting the nominal fee. So there could be some kind of like a very small fee for consumers, but it can't really be a fee that deters consumers from using ADR. Then again, it has to be fast. So if we compare with judicial redress with the courts, so one of the problems of the judicial redress for consumer disputes is that it takes a very long time. So I think that yesterday there were some discussions about courts being understaffed, and with the consumers, especially when there are small disputes, if there is a small dispute and you have to wait for a year or several years, then it's very, very discouraging. And the consumer probably will just walk away and will not fight for their rights. So consumer ADR in Europe, you need to deliver an outcome in 90 days. Of course, you can prolong it if the dispute is especially complex, but normally after 90 days, you would know, the consumer and the trader would know what happens. And again, I spoke about both voluntary and compulsory system being acceptable. On the other hand, what happens with the outcomes? So we accept different different national systems. So there are systems where you which are basically acting as mini courts. So they deliver mandatory outcomes, binding outcomes. So one example is Lithuania. There are countries where you have a traditional mediation, which is completely voluntary. There are, like in Portugal, for example, you have for expensive disputes, for high value disputes, you do have compulsory arbitration, and there are countries which are a little bit in between. So the outcome is non-binding, but it has a very, very high moral value, and there might be other consequences. Then again, we have more than 400 dispute resolution entities, and they are very, very different. And again, the countries are very different. It's a super diverse landscape. We have countries that have like dozens or even more than 100 ADR entities. We have countries who might be just as big, but they have only one or two. And there are around 300,000 dispute resolutions per year. Is it a lot? Is it a little? We will come back to this. So it's a good number because alternative dispute resolution is not the only way for consumers to deal with their problems. There are others. Then again, all countries are covered and all sectors are covered. Now, today we are speaking about the trends in dispute resolution. So in principle, we think that the ADR system in Europe works, and the Alternative Dispute Resolution Directive, our legislation, in principle, we think that it's a good law and it is transposed in member states correctly. Are we going to stop? So are we going to speak about the trends at all? Well, yes, because you might have a good law, but the law doesn't exist outside of the context. So while the law is being drafted and implemented, the world moves. 10 years after the directive was adopted, the European Commission actually says that, the directive has been useful, but we have to move on. The world has changed too much. So last October, the Commission proposed to introduce some targeted amendments. It's not a big revolution, but there are important amendments anyway. Then we also see, maybe some of you heard about the European ODR platform. So I'm actually responsible for that one as well. And what happened with the European ODR platform, that it hasn't brought the results that we expected it to bring for a number of different reasons. So the decision was to, the Commission proposes now to discontinue it. Of course, we are far from the decision yet. The European Parliament and the Council, the member states, still have to agree. And then we also issued a recommendation for the platforms, for the e-commerce platforms, big e-commerce platforms that have their own unofficial dispute resolution systems. Okay. So why we are doing that? And here is the question of the trends and evolution. So as the consumer markets evolved, then the type of consumer disputes evolve as well. When the ADR directive was adopted in 2013, the biggest problem on the in e-commerce, in digital markets, for example, was a delivery, if the parcel is going to reach you or not. Now it is no longer the case. So there are, you can have a problem with digital content. You are still the consumer, but there might not even be a purchase contract. So the modernization directive that was adopted in 2019, just before COVID, and in this way it was ahead of its time, basically says that you can still be a consumer if you didn't pay the price. So the fact that you gave something to the trader, like for example the use of your personal data, is enough. You still you are covered by the consumer law, and you can have the consumer dispute. Then again, digital advertising, Right now, if you are, purchasing online, whether it's something physical or it's a streaming services or you book your tickets, there are so many things that can be done to influence your decision. And sometimes, you can be influenced into making a decision that is against your best interest. So, and the European Commission considers that in this way, if you are kind of tricked into making a decision which is not for you, you are also in dispute, and you should also have access to the alternative dispute resolution. Then again, outside of the contract that you have access to the basic services, like, for example, you change the country, or that was actually the case with your compatriots, with Ukrainian citizens who were arriving to Belgium to seek temporary protection. Once they receive their temporary protection, they would need to open a bank account. You do not have a contract yet, but you are already in the dispute if the bank is reluctant to give you a bank account. So again, access to the basic services. Then again, there were more and more purchases internationally, and then again, as a part of a digitalization, we should leave nobody behind. So we allow any kind of a procedures, but we need to look that the procedures remain inclusive and accessible for all. Otherwise, those who have maybe issue with digital literacy or issue in using computers, you are at disadvantages twice. First time when you need to purchase something, and then second time when you have a dispute. Okay. Then, the biggest trend that we have, that the Commission wants to introduce, is that we want to move away a little bit from a complete laissez-faire attitude, because right now,
Excuse me, which attitude?
laissez-faire, with a completely voluntary attitude. Okay, I rephrase, from the completely voluntary attitude. So right now, ADR in Europe can be either completely voluntary or it can be compulsory. What we see that too many traders are ignoring the alternative dispute resolution entities. So the latest information that we have in Consumer Scoreboard is that basically only a third of the European traders are willing and able to use ADR. So we are very, very far from compulsory ADR. This is not what the Commission wants to do. We still think that ideally it should be voluntary, because ideally both parties should want to be behind the table. But what we want to introduce the duty to reply, that even if the national system is completely voluntary, and even if the trader does not want to take part in the procedure, then they are obliged to react to the inquiry of the dispute resolution system. So they are obliged to tell if they are going to take part in the procedure or not. So this is also an instrument to engage the traders, because from our research, it turned out that the biggest obstacle to the ADR, especially in the cross-border context, when you have consumer in one country and trader to another country, is that the traders do not trust dispute resolution entity. They don't know enough about it. They don't understand it. And in this case, it's very, very difficult to trust something which is abstract. It is very difficult to trust something if you don't understand the information that is given to you. So we want to nudge parties, to push a little bit parties into the dialogue, even if this dialogue is only about taking part in the procedure or not. So the traders will have to read, at least read a little bit about the ADR entities, and then it creates awareness. And according to our logic, awareness creates engagement. We hope that we are right, but now again, as I told, the process has just started, so it depends very much on the trialogues with the Parliament and the member states. Okay, and then of course we want to make ADR more effective. So we want to encourage the dispute resolution entities. Again, a lot of consumer disputes are very, very similar. Like, for example, you have flight canceled during beginning of COVID. A very, very big problem were canceled flights, and the companies not paying back, only giving vouchers. So these are, like really, really standardized disputes. So we want to help the dispute resolution entities to process them quicker. So we want to allow them to basically encourage member states to allow them to to handle the standardized disputes together. And then we are not prohibiting. So in terms of technological assistance, we are not speaking about robotic mediators. Again, we are very far from it, and we think that still mediation, dispute resolution is still a human activity. But if you use technology to assist, to make dispute resolution quicker and more coherent, you can do that, but it has to be done in full transparency, and the parties should be able to ask for the human review, okay? And we will also ask the member states to establish the contact points of alternative dispute resolution. So there will be an advisor, at least one advisor in the each member states that will actually popularize mediation and dispute resolution for consumers and for the traders. So then again, Commission will have new role, mostly in terms of informing consumers and traders. So now the ODR platform wasn't very effective. Again, traders did not use it enough. We really worked a lot on it, but we were not able to, really turn the tide and to make it, to make it something that would really transfer a lot of disputes to the human mediators. But instead of that, so the role of the Commission will shift from providing the ODR platform to move disputes to the dispute resolution entities, to have a user-friendly tool that will allow consumers, and why not traders, to understand disputes, to understand the options to obtain redress, and to also understand their rights. Again, so here I have to look at my other screen a bit, because even if I'm Estonian and I understand Ukrainian a little bit, I don't understand too much enough to read from my slides. So I have to look at my other screen from time to time a bit. Sorry about that. Again, consumer ADR in the European Union is one of the tools in a very, very big toolbox. We have informal systems like European consumer centers that provide advice to consumers and informally intervene with the traders. There are public enforcement bodies that deal with, like illegal practices. We have the courts play their own role, especially in the cases of mass harm. So sometimes you do need legal intervention, like for example with Volkswagen, the so-called Dieselgate, when there was misleading information on Volkswagen cars. There actually nothing was moving very much until you had a court decision. So there will always disputes where you need a court. And then for the mass harm situations, we have the Representative Action Directive, where consumer organizations can submit. It's like more like an almost like an American system, that you can submit a class action, really mass claims, and other consumers can join it at a later stage. And then on the other hand, what is, like really, when we speak about the European context, the strong consumer organizations are very important, because these are the first port of call of the consumers, and these are the ones that alert the enforcement authorities of the malpractices, and these are the ones who help the ADR entities also in their work. Okay, so this is like a bird's eye introduction of where we are in the European Union with the ADR and where we are moving. If you want to have more information, there are, I imagine that all our slides will be shared with the participants. So there are some links to read more about us and about the consumer rights to the EU. This is all I have today for you. And back to you, Sofiya, Iuliia, thank you very much for your time.
Дуже дякую, пані Маргарита.
Thank you so much, Margarita. This is an extremely important and interesting presentation. All in all, it was very interesting to see and hear how your directives in the European Union sometimes have to be adaptable to the changing and vibrant world. Because, like you said, the nature of the disputes is changing all the time. There's new emergent technologies that comes into play, and I can see how you're trying to actually be always in line and always to be updated. Thank you for admitting the importance of disseminating information about ADR opportunities. For me, I think, and I'm sure for the participants today, this information was so valuable. Awareness leading to engagement, that's great. In case our forum participants have questions, please type them in the chat. And I will probably take advantage of my moderator's role and ask a question to Margarita. Maybe you've had some experience about where are the biggest challenges in implementing EU directives across the European Union member states? If they're transposed really well all the time, or you're sometimes facing challenges? And if so, what are the challenges in transposing the European legislation into the national?
Oh, thank you very much for your kind words. It's, like, again, it's great to engage. So about the challenges. So, of course, everybody wants to know challenges. I would tell you that actually the biggest challenge that we have in transposing this directive is the cross-border context. Because European consumers, especially in digital markets, you buy online all the time. And sometimes you don't know that you buy cross-border. Like, for example, a German consumer who buys from the Amazon site, which has like a German extension, amazon.de. They don't know they buy cross-border. They don't know that they buy from the company in Luxembourg. And there are a lot of situations like this. And here we have a situation when the consumer, even if consumer is aware, the consumer is aware of their own ADR situation, of the national legislation. The trader is somewhere else. The trader is playing according to completely different procedures. Material consumer law is harmonized in the EU, but the ADR procedures, they can be very, very different. And sometimes it can be very confusing. So one of this, actually, that was one of the biggest challenges that triggered us to see how we can simplify the ADR procedures. How we can, like, again, here is the bundling, here is the, like, less red tape, less maybe reporting, which is not necessary. More use of the better use of the automatic tools, technology, the contact points, ADR contact points that can help with different, like with the information if you have a cross-border dispute. And of course, the other big challenges is on top of our official ADR entities, there are unofficial ones provided by the online platforms, e-commerce platforms. So now the Commission is working on trying to get them be more compliant, more transparent, more sensitive to consumer law. But actually the biggest challenge is traders' engagement. So if we manage to increase the trader engagement, and now we, like we are trying to do that, working with the duty to reply and also the network of the contact points, then, like you have this 20-80 principle, Pareto principle. So you get 80% of the outcome with 20% of effort. So basically, if we resolve the question of the traders' engagement, then basically we resolve most of the challenges.
Thank you so much for your topical answers. And I also shared in the content in the chat that you made very important accents on many important things. So now it is a pleasure to hand over the floor to my co-moderator. Please, Iuliia, introduce our next speaker.
Софія.
Thank you, Sofiya. I'm so glad to welcome all the participants in this panel discussion. I'm sure we all are going to get a lot of practical experience and knowledge. Special role in ADR in consumer disputes is played by empowered authorities that foster standardization and reliability of the procedure. And such policies as they are governed by, they are developed with a view to the needs of consumers and businesses. This allows to ensure the alternative dispute resolution procedure with impartiality and fairness. So, we're going to listen to our next speaker about these organizations and these best practices, and I'm happy to welcome our Greek expert, Georgia Angelidaki. She's an accredited mediator, lawyer, GDPR advisor, and a member of the board of directors at GEMME, Hellas. Please, Georgia, the floor is yours.
Vitayu said well.
Yes, super.
Okay, so you can hear me well. Okay, first of all, a nice welcome. It's an honor and a privilege to be invited to participate at the 8th International Forum on Mediation and Law, and I'm delighted to be here today with all of you. I bring literally with this heat warm greetings from Greece and best wishes from GEMME, the Hellenic Judges Group for Mediation. And I wish to thank the President of Ukraine Academy of Mediation for this kind invitation to share with you my experience and opinion about ADR bodies on consumer disputes. Margarita, at her nice presentation, said a lot of things. So I will speak about the ADR entities. So we know that the alternative dispute resolution is defined as a process allowing complaints to be settled out of court with the assistance of an impartial dispute resolution body. Under European law, and today I speak about the current legal framework, the current directive. And under, as I said before, the European law, ADR can be used for any dispute arising from a contract between a trader and a consumer, whether the product was bought online or offline, or whether the trader and the consumer live in the same or in different EU countries. We can say that each year around 300,000 disputes between consumers and traders are examined by ADR entities. But the big question is, what is an ADR body? An ADR body is an impartial organization, or can be also an individual. That should be the person or the organization that helps consumers and traders resolve the disputes without going to the court. And this is important. ADR bodies have existed in many European countries for some time. Dispute boards, arbitration services, and conciliators, mediators, even ombudsmen, all these can be considered ADR bodies. What baseline standards do notified ADR bodies have to comply with? And we're speaking notified under the directive, and especially in the competent authorities, national authorities in each member state. So ADR bodies that are notified under the terms of the ADR directive, the current, as we said before, must comply with the following standards. They are impartial. Impartial is the key word for all the ADR resolution systems, that's correct. So will usually be fully independent from the consumer and the trader in dispute. And also Margarita said so, in some cases, trader groups may be allowed to finance approved ADR bodies, but only under strict conditions that guarantee the impartiality of the dispute resolution process. They are competent. They must be expert in ADR procedure so that the services that they provide can be both fair and effective. They will also be expert in law in the area of areas in which they work. For example, an ADR body that deals with consumer disputes related, to air passenger rights, who know the law in this area. Affordable, bodies must provide their services for free or for a nominal charge. They are efficient, should complete a case within 90 days, except for disputes, for exceptional complexity that may take longer, of course. It should not be necessary for trader, it is very important, or the consumer to physically attend the process, and neither the trader or his customer would need to use a lawyer. They are transparent, and this is most important, the most important issues. Notified ADR bodies will publish details of business sector they deal with. Maybe they can deal only one sector or many of them, or maybe they can be for specific sectors only. So they will, I'm sorry, they will publish detail of business sector they deal with, the procedure they employ, the cost, if any, and the legal consequences of their decisions. They are also required to publish reports giving information on the number of disputes handled, the number and the nature of disputes which they refuse to deal with, and the average time taken to resolve a dispute. We said about that there is a possibility for any country or a sector that must choose a specific factors if they can apply. And let's see in more details the article for the transparency of the directive. I'm sorry to take my glasses. So the Article 7 of the current directive about transparency said that the member states are ensure that the ADR entities make a publicly available on their website or the app or the on-editable medium upon request in appropriate, clear, easy, and understandable information on the contact details, the fact that ADR entities are listed so that means that they are notified to the competent national authorities, the natural person in charge of ADR, the method of their appointment, the expertise, the impartiality, the independence of the natural persons in charge of ADR, their membership in the network of other ADR entities. Of course, as you said before, the types of disputes that they are competent to deal with, the procedure rules governing the resolution of a dispute and the grounds on which the ADR entity may refuse to deal, the languages in which the complaint can be submitted, the types of rules the ADR entity may use as a basis, and of course, any preliminary requirements that the party may have to meet before an ADR procedure. As an example, that the customer, the consumer must try to be in touch first with the trader. So, this is important about the transparency. Of course, you said about the cost and the legal effect of the outcome of the ADR procedure and the enforceability of the ADR decision, relevant or not. So they can use different methods. We said so, or it must be can be arbitration, can be mediation, can be mixed. And I was thinking to tell you about the changes that the new proposal will has come in light, but Margherita very detailed said so. I will stay to underline that the added value of ADR entities is their ability to be agile and help consumer and traders reach an amicable solutions without having to go to the court. And I'm sure that the ADR system has proven to be an efficient and effective way to settle disputes. Also, I can say that the retailers across Europe highly value the possibility that already be offered by ADR schemes to find amicable solutions to the contractual disputes with their customers without having to go to the court. Of course, it helps foster good relations with customers by finding the right solution tailor-made for them to the specific cases. So, and speaking about Greece, if I can share with you our experience, and according to the Greek report for our European Consumer Center, is noticed that there is a very high degree, it's about 93%, it's very high, of the I'm sorry, the response of traders, I'm sorry, the response for traders to invitation to amicable resolution process. That you have to underline this percent, because it is too high, and we're speaking about SMEs in the majority of the cases, and that is still voluntary. We have to remember, we must not forget that NDR entities are dispute resolution bodies. They are not courts, they are not competent authorities, and they are therefore not responsible for interpreting the law, but to help the two parties, the consumers and the traders, to find a solution. If I'm okay with the time, Iuliia, Sofiya, in time, I have to add my opinion, my personal opinion, that to make sure and to avoid the dispute before this arising, to prevent, is to have a nice information and awareness. I heard very carefully Margarita said that the traders ignore the ADR system and the ADR entities. I believe so. Not only traders and consumers. I think it's very important, the right information, the right awareness, and of course, training. And those three words are the key words to help a consumer and traders and the internal and national market. So I strongly believe in the training, and I can recommend it to you and to share with all of you and from all over Europe the project Consumer Law Ready. That's a specialist training program for people in SMEs, is in all the countries of Europe, and it helps to understand and comply with the latest EU consumer laws. The training enables the trader to gain knowledge of the important aspects of consumer law, which will help to improve customer services and increase consumer trust in their business. We are using reading materials, video quizzes, a test, and traders will obtain the notices required to ensure that the SME is consumer law ready. And as it is chaotic, or consumer law is chaotic, we have to admit that. And when is the time to come and to settle a dispute, I think that both parties must know which is the law. But at the end of the day is to have a nice settlement. Via Caillou, is that correct?
Дякуємо, Джордже. Дякуємо за ваш
Thank you so
виступ, за
much,
те, що
Georgia. Thank you very much
поділилися
for
грецьким
your
прикладом у
presentation and for sharing
альтернативному
some of
вирішенні
the
споживчих спорів.
ADR best practices from Greece.
І я прошу наших
So
глядачів
I would please encourage our audience to
запитання,
ask
і
questions.
можете це робити в чаті,
And you can do it in the
піднімати
chat,
руку,
of
якщо вам
course,
так
or do it
комфортніше.
by raising your hand if you find it more
Поки
comfortable
всі
for you.
налаштовуються задати
And while
запитання, я
everybody is
як
getting ready
модератор
for
хочу
questions, I, as a
уточнити
moderator,
вас,
would like to
Джордже,
specify one thing,
як,
Georgia.
на вашу думку,
What do you
чому
think?
Так. Ага. Чого ви навчаєте своїх слухачів як тренер в проєкті
What do you
до
think
захисту прав
it's
споживачів?
important to train our people? What do you make the
увагу?
most emphasis of your trainees on? What's the main focus of your training agenda?
Speaking about?
Будь ласка, так.
In your training, what do you mostly focus on? When you
Oh,
deliver training to other people, what do you focus on primarily?
you're speaking about SMEs.
Мгм. Так,
Okay.
так.
As I told you before, consumer law is chaotic. This is true. And the first thing that I'm doing is to interview the SME, to make sure which is their needs. Because every SME is different from the other, as we are all the human beings. That's correct. So I would like to ask first what their needs, what they are usually affront, and which is the problem. And so then I try to help them on these issues about also every specific sector. But what I want to say and share with you is this, that during, I'm sorry, we are speaking, especially in Greece, for SMEs, that they is not exactly the definition of the European Union that you have in mind, especially with the turnovers and the balance. We're speaking about usually owners and or 1 or 2 employees, so we are micro. And if you are thinking that there is the 92% of the companies, they are small, so we're speaking about a lot of companies. And the other thing that we have to keep in mind for my country is that we still have the neighborhood. And we like that. We like to have the small natural stores, offline stores, that Iuliia, you will come and visit us, and we know that Iuliia likes to read this kind of books, or like to, I don't know, wear black clothes. And they are trying to have a very nice relationship with the clients, the customers. So they are trying to do, and they are doing more than the law asks for, you know. And this is important because they try to satisfy the customer. And during one training that I had, I remember that was the general manager of the marketing. And especially we're speaking about ADR systems and ODR and all the information that the trader has to give to the customers. And I said that there are obligations. And he was so polite, and he said to me, you know, Angelidaki, it's not about law. It's about consumer satisfaction. And I kept this phrase, I like it. And I think that it's important, both of them know their rights, their obligations, and they try to honestly find a nice solution for both parties to can keep going, as general mediation does. And that this, they own it, you know. And I think that the most nice thing for SMEs is that they can participate, they can give a perspective, they can hear the customer. So also the part that the consumer must come first to be in touch and to ask information from the trader is a very nice step. But the knowledges and the information, I think that is the key word. So I think I shared too much, but it was a very nice feeling that I had then, is that we must understand, we must try, we must have good knowledge and to do the best for the market.
Дякую, Джорджія, що поділилися з нами своїми
Thank you very
думками,
much,
своїм
Georgia, for
досвідом. І
sharing
я
your
впевнена,
experience
що
and your
люди,
thoughts
що
with us. And I'm
хочуть
sure the
кожна
more
країна перейме
every
досвід
country
з
will
інших
borrow from the
країн,
other. I
тим
mean, in terms of best
ефективніше можна
practices, the more
підійти
efficient
до
we will be
власної
doing
системи
in building
альтернативного
our
вирішення, в
own
тому числі і
ADR
споживчих
system,
спорів.
including in consumer
Дякую ще раз, Джорджія.
disputes.
Пропоную
Thank you
перейти
so
до
much. Let
наступного
us move to
спікера.
our next
Софія, тобі
speaker.
слово.
Sophia,
Будь
the
ласка,
floor is now
представ
yours,
шановного
please.
спікера.
can you introduce our next
Дуже
speaker?
дякую, Джорджія, дуже дякую,
Thank you very much,
Юлія.
Georgia.
З
Thanks very much,
радістю
Iuliia.
представляю, хочу
I will
представити
gladly introduce
наступного
our next
спікера,
speaker,
пані Енді Роджерса.
Andy Rogers.
Пане Енді, я бачу, що ви з нами.
I can see you're
Пане
here.
Енді
That's
медіатор,
great.
попечителем і
And
директором
he's a
управління
mediator
захисту
and a
пенсійної
trainer at
медіації.
CDR,
Пан Енді
Director of
поділиться практичним
CMC
досвідом вирішення
from the
судових
United
спорів у
Kingdom.
Великій
He will tell us a
Британії.
bit about
Оскільки пан Роджерс є
consumer
членом
disputes
виконавчої
in the
ради
United
Центру
Kingdom.
ефективного вирішення спорів, він також розповість сьогодні про участь
And I'm sure Mr. Rogers will tell us about the role and experience of the organization he represents in alternative dispute resolution. And we can't wait for more information from you, Andy. Thank you very much.
Thank you very much, Sofiya, and it's a real pleasure and honor to be speaking at this conference. I'm very, very happy to be here, both on behalf of all the organizations I work with, the Centre for Effective Dispute Resolution in London, the Civil Mediation Council of England and Wales, and also the International Mediation Institute, of which I'm a director. But I know that you have other speakers from IMI during the course of the conference, as well as another speaker from the Civil Mediation Council. I am going to speak about consumer dispute resolution in the UK primarily, and a lot of that will be about the experience of my own organisation, which does a number of things. So we are a training provider, we are a not-for-profit campaigner for different ways of resolving disputes. We are also a mediation centre, but we also specifically have contracts for consumer dispute resolution. So the environment in the UK has been shaped by, unsurprisingly, by our previous membership of the European Union and the ADR Consumer Directive of 2015. So a lot of the structures that we have in place now come from that, but obviously as well there are different consumer laws and consumer rights. I think one of the things in the UK that makes it a little bit different is some of our laws and rules are quite old. So we have very specific laws. For example, my organization will deal with any complaints about the postal service. And there are specific laws in the postal service that mean that you cannot make a complaint or file a legal case to say, for example, I posted my mother's diamond ring in the post and it hasn't arrived, and therefore you owe me $10,000. That's not possible because in the law it says the most you can claim back is the cost of the postage plus a little bit of money for inconvenience. So the most you might get back is maybe £10. So a very, very small amount. In addition to that, obviously we have newer consumer laws. Margarita talked about the EU Regulation 261 on delayed flights. When the UK left the European Union, a lot of the regulations were passed automatically into law, so we still have that regulation, and that's an area of disputes that my organisation gets quite involved in, both in the UK but also with other airlines travelling around Europe. One of the things that the EU regulations did was introduce the concept of the competent authorities, which has been touched on already a little. There are a number of different competent authorities in the UK. The main one is the Trading Standards Institute, but there are various other ones as well, and I will touch on some of those as I go through in my presentation. The other element, obviously, because the UK is a common law jurisdiction, is that we have case law, and some case law applies in different ways. One of the most interesting bits of case law that has come in recently in relation to mediation is the Churchill case. So this is nothing to do with the former Prime Minister, but it is a case it was a housing dispute with a local authority about weeds that were destroying a house. And basically the nub of the dispute was that, and the argument that went to the Court of Appeal, and it was heard by the highest judges in the country, was that could the local authority that was responsible for the housing make someone go to into an ADR process? And the judges said, yes, you could. And this means that it is possible in the UK now to have compulsory mediation. This was done after some important studies had been done in the UK that showed that making people go to mediation was not a breach of their human rights. So we now have an interesting and exciting time. And the environment in the UK for consumer disputes can kind of be split into two areas. I'm going to briefly talk about one and then spend more time on the other. So the one I'm going to talk about briefly first is small claims mediations in the courts, and then I'm going to go into more detail on the wider consumer ADR field. So small claims in the UK are defined as disputes under £10,000, and there has been mediation offered in this area for a long time now. The government first started thinking about it 20 years ago, and it was introduced by 2007. So the government employs small claims mediators. They have always had a small number of them. That's now recently increased, but it is free for the litigant to use. There is no charge for using this service. The mediators are employees of the courts. The small claims service is a telephone mediation, so there is no meeting in person. The mediator will contact the parties by telephone. The settlement rate is not amazingly high. Well, I'd say not amazingly high. It's better than 50%, which is obviously a very good level to be starting at. However, as the previous speaker was mentioning, the satisfaction rate is actually really very high. The satisfaction rate is usually in the level of 90% of the parties feel very happy that the mediator has reached out to them, and they feel that it was worthwhile participating in the process. So even though their case doesn't settle, the vast majority of people feel it was worth trying to mediate, which is a very good place to be in. So from an early start with piloting a small number of in-house mediators in the courts, they quickly got to a level of around 23,000 mediations a year across all of the courts. But things have started to change now. The main thing that started to change is there is more of an emphasis in the UK on having an online court for smaller claims. So there is not the option to turn up somewhere in person. You have to file your papers online, and it may be that it becomes more appropriate at some point in the future for the mediators to mediate online rather than over the telephone. But at the minute, it is a telephone process. The most important thing that's changed really quickly, which is just in the end of May, is the government have made it compulsory that every small claim has to go to mediation. So that number I mentioned of 23,000 cases a year, that should go up considerably quickly. Yes, very quickly. So at the minute, it just applies to claims filed on paper, which is a smaller number, but by September, it will be all claims filed online or in paper will have to go to mediation. There will be some exceptions, but in most cases, if you are a consumer and you have a dispute with someone for a low amount, if there is not a regulatory scheme for you to go into, the default is you will go to court and you will have to have a mediation, and that mediation will be provided by the state. On behalf of the Civil Mediation Council, I'm currently talking to the Ministry of Justice about expanding that for more disputes. But once a dispute gets to a level over £10,000, it is no longer considered a consumer dispute. So I won't go into lots of detail about that at the moment. But yes, the fact that it's mediation is becoming compulsory or mandatory is all due to this. Is helped in part by the Churchill case that has now said it is judges have the right to send people to mediation, and it is not in breach of their human rights. So it is a positive change in the UK. I said I'd spend more time talking about the other area of consumer mediation, which is in some ways bigger, because partly inspired by the EU Consumer Directive, but also because I think a lot of industries were working in that direction anyway. A lot of industries in the UK have an ADR scheme or some form of ADR as a recourse for when a consumer is not happy with business in their industry. So there are many, many of those. If you are bored and you want to go to CEDA's website, which is www.cedr.com, and you click on the consumer tab, you will see, if you scroll down a little bit, there are 18 different sectors that my organization alone provides some form of consumer ADR in. So these are areas where we have been appointed by a regulator or contracted by an industry to provide an ADR service. So this is everything I mentioned, air travel, telephone services, water services, but there are, not every sector will use the same approach and will use the same process. There are certain industries that are more likely to use mediation. Other industries might use something closer to an ombudsman process or an investigation and an adjudication, sometimes even an arbitration. When people want certainty, they will have a paper-based arbitration. But as I say, there are certain industries that are more likely to use mediation, and I'm going to list some of them now. The biggest one, certainly for my organization, are disputes over funerals. So when a family member is unhappy with a funeral that's taken place, rather than having to go to court, the funeral organization will, after initially trying to help with their complaint, will bring it to my organization, CEDA, for a mediation. Another area is new homes. So if you buy a home that is newly built and you're unhappy with your home, you can go to a mediation for that. Private healthcare disputes, so not disputes that are done through the, or healthcare provided through the states, but private hospitals, you can get a mediation there. What are some of the other areas? Putting new windows into houses, you can have a mediation over that. If you buy a caravan or a mobile home for your holidays, you have a lot of money and something goes wrong with that, then again, you can have a mediation. What a lot of these processes have in common is that they are issues that people feel emotional about: a new home, their health, a funeral. They want to be able to talk about them. And so having recourse to a mediator rather than a process where you just fill out a form and someone that you never have any contact with makes a decision, doesn't feel quite so good. I've left out actually one other sector that we do mediations on, and that is Botox. And that is because in a dispute over Botox, people that have Botox often go into the process thinking, I'm going to come out looking perfect, like a different person. And actually, often the person comes out looking like the same person, but with Botox. And it means that their reality hasn't been met. They're very unhappy. They don't want to go through an impersonal process. What all of these processes have in common is that they have to be quite short in order to be cost effective, because these are not large amounts that are at stake. So the processes are typically taking a couple of hours. So in order for this to happen, you need very good information for each service. You need information in terms of what are the rules of accessing this mediation, what needs to happen, how do I prepare for this mediation, what information do I need, how do I clarify my thinking in order to prepare. So these are very important things, and we have, for a lot of our services, we will have a little video that you can watch sometimes to help people prepare, but certainly we'll have guidance. We also have the everything is filed online. We do have provision for people to file through papers through the post, but most of it is online. And one of the interesting things is, if you are asking both sides to put their cases on paper online prior to the mediation, do you allow them to see each other's papers? And if you do allow them to see each other's papers, do you allow them to negotiate directly before the mediation has happened? Some of the industries we work with are very happy for that to happen. For example, if you are a company and you've been in dispute with another side and you don't believe them, you haven't seen any evidence, and then all of a sudden they present their case with evidence, then maybe as the company, you think, actually, no, I will offer them some money. And it can be more effective to do that prior to the mediation. So there is that consideration as well. And then obviously, because these are under the EU directive, for every ADR scheme, there must be a competent authority. My organization, CEDA, has to report on the cases, what the issues are, whether they were resolved through mediation. I wanted to finally touch on how these cases are mediated. So we have panels of mediators. For ordinary mediations, we have about 85 mediators in the UK. We have another 75 mediators around the world. About 50 of those are in Europe. But specifically for consumer disputes, we have around maybe 120 neutrals, some of which will be mediators, some of which will be adjudicators, and they will work across different of the industry sectors and schemes that we offer. But all of our mediators are given training in terms of how do I start preparing to be a mediator, to do these small claims. The process, because there is less time, is different to a mediation that runs for a full day, obviously. When CEDA trains people to be mediators, we always say you need to understand the interests of the parties first before you can start negotiating. When you have very limited time, sometimes you really have to get to the interests quite quickly and even start negotiating while you're still uncovering the interests. So it is a slightly different process in terms of what the mediator is doing. The format is obviously, it's quite difficult to run these in person. So typically they happen online or even over the telephone. And for some of them, more typically, it is over the telephone. Certainly the funeral disputes I was talking about, they would almost always happen over the telephone. And finally, and this I think is one of the more tricky elements, is some of the industries that CEDA work with want a definite outcome from a mediation, or that they want as good a chance as possible of an outcome. And obviously you can't always guarantee that a mediation will end in settlement, particularly if you don't have a lot of time. So in those cases, the mediator is invited to write a recommendation. So it's not a binding decision like an arbitrator, but they can write a recommendation based on having spent time hearing what either side are interested in. The rules will typically always say that if the consumer accepts the mediator's recommendation, then the business has to honor that. So the mediator might say, well, having heard everything that went wrong with the fitting of the new windows in your house, it is clear that actually these elements of the contract were not followed. I have heard that on this side, the consumer wants this amount of money. On the other side, they've explained that actually the cost of this is usually this, or this is what is reasonable, therefore I recommend a payment of this amount. And obviously, as mentioned before, these are not amounts over £10,000, so they're not big amounts, but the mediator will make a decision. It's very, recommendation. It's very important that in the mediator's recommendation, they are very clear and there are no mistakes, and that the mediation recommendation is often checked to make sure that it feels safe. But that is very much a last resort, and the mediator is always aiming to get a settlement within the time. I realise that I have now given you a lot of information in a very short period. There are probably lots of other things that I could have mentioned as well, but I will now hand back to Sofiya for any questions you may have.
Дуже дякую, пане Енді.
Thank you so much, Andy, for sharing these practicable and instrumental experience. You know, I can see no questions in the chat, but being the moderator, I will allow myself to ask a question. How ECDR is measuring the success rate of what you do? You said you have to report sometimes and show the number of cases you have handled, what challenges you have faced. But how do you measure the success rate of your organization? Maybe in consumer disputes.
Yeah.
And what are the measurements or criteria you're using to measure that? Thank you.
So I mentioned before with the courts that those mediations are now becoming mandatory, so people have to go. With the services that my organization offers, it is not mandatory or compulsory. So every year across all 18 industries, in an average year, we may have something like between 19 and 23,000 claims filed with us. But of that huge number, maybe only a fraction go ahead. So maybe 7,000 cases will go ahead and a proportion of those will be mediation, but some of them will be other processes as well. So of the mediations that go ahead, there is a reasonable chance of success because people have been told this is what the service involves and they're willing to try it. So actually that is quite a positive thing. So the success is pretty good. So we will also want to report on how our administration has been. So did people find it easy to access the service? Was the information clear? Were we sufficiently helpful in explaining what people needed to do? And then obviously, how did the mediator perform? And then finally, of course, was the mediation settled? When the mediation is settled, we always make sure that the business honors the settlement, so the business pays the consumer, and we will not close the file on the case until we are notified that by the business that they have paid the consumer the money that they agreed to in the mediation. So it is in these ways that we try to evaluate our mediations for consumers.
Дуже дякую.
Thank you very much.
Трішки бачу питання
I
в
can
чаті.
see one more question in the chat. We're a little bit late in terms of time, but maybe we will
останнє питання з
try
чату
to
запитати.
handle the last question in the chat.
Щодо того, я задам
There is a
англійською,
question.
Do you find CDR receives a good response rate to those surveys?
Yeah.
And якщо ви ще з нами, можливо, коротко прокоментувати.
Maybe you can talk about those response rates to the surveys.
The response rate is reasonable. It's not brilliant. It's always, I think, a little bit difficult because people have moved on from the point of the mediation. So I would say the response rate is actually probably better for consumer mediations than it is for larger mediations. But I would say in consumer mediations, the response rate is maybe 60%, something like that. 60% of times we will get a good result. We try to, we use basically a SurveyMonkey system where there is just one page of questions. So it's not that you have to go through 20 questions. There's 6 questions you are answering in terms of how satisfied you were.
Я бачу ще одне
I
питання.
can see one more
Можливо,
question in the
останнє
chat.
питання
Let's
задамо,
do the
потім
last one
будемо
this time.
відпускати. Також я
And then
знаю,
we'll
що нас
let
чекає
Andy go.
наступний спікер.
Because we're waiting for
можливо,
another
останнє
speaker. So
питання.
Andy, can I ask another
You
one?
mentioned in your presentation that the mediator wants the parties to do the dispute to reach an agreement as soon as possible. How does the mediator's position, as you mentioned, relate to the neutrality of the mediator?
So I think the mediator wanting to try their best to get the panels to have an agreement means that, yes, to some degree, the mediator does have a stake, but the mediator is not being paid on their result. The mediator is not being paid for every settlement they get. The mediator is being paid for every mediation, regardless of whether they settle. So I think the mediators always know that it is the choice of the parties to make a deal, but it is the mediator's job to see what the best deal possible on the day might be. So I would say in answer to the question that is what the mediator is focusing on. So yes, you can argue that the mediator has an interest in getting the settlement because the mediator would like it to be resolved, but the mediator will always accept it is the party's choice.
Дякую вам, Енді.
Thank you so much, Andy.
І враховуючи
You're welcome.
те, що вже ми трішки
Given we are a little bit late over the limit of time,
нашу дискусію буде сьогодні
but our
завершувати
discussion will be
людина,
closed
яка
by
вміє
another
заглядати в
expert
майбутнє і
who can look
випереджати
into the
час.
future
Ми
and be
раді
ahead of time.
запросити Коліна
We're
Рула,
happy
президента
to
і головного
invite Colin
виконавчого
Rule,
директора
President and CEO of
ODR.com,
ODR.com,
Arbitrate.com, за
Mediate.com,
допомогою
and
онлайн-системи для
Arbitrate.com
вирішення спорів, яку
with
пропонує
an online
ODR.com.
dispute
Безліч
resolution
компаній з усього світу
system.
змогли
Numbers
вирішити
and numbers
конфлікти
of
і зробили
companies
це
managed
швидко і
to resolve their
ефективно.
conflicts
До того
and
ж,
did it
у період з
effectively and
2003 до
fast.
2011
Between
року пан
2003
Рул
and
був директором з
2018, Mr.
вирішення
Rule was
онлайн-спорів
a
для eBay
CEO
і PayPal,
for
і я
a
впевнена,
director
що
in
його
ADR for
презентація буде
or
надзвичайно
ODR for
корисною
eBay and
для
PayPal.
усіх нас,
I'm sure this
тому
presentation
просимо
will
вас
be
до
fun
слова.
and a very important one for everybody. Thank you. The floor is yours, Mr. Rule.
Thank you, Iuliia. And hello, everyone. I'm also honored to be part of this fantastic gathering with amazing speakers from around the world. And I know I'm sort of bringing in the final chapter here, so I'll keep it short. And then I loved what Iuliia said about trying to move into the future and reclaim some time. So I'll do my best. Let me share some slides here very quickly, and I'm happy to share these with the organizers as well, so everyone can have them. I just wanted to briefly speak. Iuliia mentioned that I was the director of online dispute resolution at eBay and PayPal for several years. At the time, eBay was the largest e-commerce marketplace in the world, but now there are many others that are larger. Amazon is about 5 times as large as eBay, and now Alibaba in China is larger than Amazon. But we built a platform at eBay called the Resolution Center, which provided fast and fair resolutions to all of our users around the world. And by the time I left, eBay was resolving about 60 million disputes per year. I'm sure that number has doubled since then. And we got to the point where 50% of those disputes were resolved amicably, meaning the buyer and the seller worked out a resolution by mutual agreement. And 90% of those disputes were resolved in software only, meaning the parties interacted with an algorithm in order to achieve resolution. Much like the CEDAR programs, and I'm a huge fan of the work that CEDAR has done, our process is extrajudicial. It is not mandatory. And the outcomes that we delivered at eBay were not enforceable in a court. We had a private enforcement process at eBay. So if we decided that a buyer was entitled to a refund, We, because we managed PayPal, the company where the payment was made, we had the ability to take the money away from the seller and give it to the buyer. And if the seller did not have enough money in their account, we would take their account negative and reimburse the buyer ourselves. So when the seller got more money into their PayPal account, it would go to reimbursing eBay and PayPal. Now, this process, when I started working on it in the early 2000s, was quite innovative. And I think it sparked a lot of discussions around how can we deliver consumer resolutions in high volume, low value cases, particularly those that cross borders. And it was very interesting to hear what the European Union, European Commission is doing on this front. But we have now seen over the past 20 some odd years, a real expansion in the use of online dispute resolution for these cross-border consumer disputes. CEDAR has innovated in the UK. Canada has something called the Civil Resolution Tribunal, which is an online court for resolving cases where people don't have to show up in person. India is launching a nationwide system for resolving consumer disputes around digital payments. And we talked before about the ODR regulation and the UNCITRAL, the UN working group on ODR that met for 7 years. So we're seeing a lot of expansion of ODR programs. I am involved in several international efforts around promoting online dispute resolution. You can see APEC, which is the countries that ring the Pacific Ocean. They have created a framework for using ODR to resolve cross-border B2B disputes. The OECD funded a project to build online dispute resolution in Latvia, and their report from that project is freely available. Niti Aayog, which is the government research agency in India, has created an ODR policy plan, again, that discusses providing fast and fair resolutions for consumer disputes, particularly in digital payments. And I am currently heading the US delegation to the ISO Technical Committee 321, which is trying to issue standards for e-commerce, cross-border e-commerce transactions. And one of the 4 areas of focus is online dispute resolution. So it's very exciting to see many of the ideas we came up with at eBay and PayPal for our particular marketplace have now been adopted widely. And many governments and consumer protection bodies around the world are realizing we need to have fast and fair resolutions for people who are transacting online. And ODR is the foundation for a lot of that. So I do urge you to check out any of these resources. They're all publicly available on the internet if you'd like to learn more. But I want to speak very briefly also about the rise of artificial intelligence in consumer dispute resolution. In the ODR field, we have a key concept called the fourth party that was created by Janet Rifkin and Ethan Katch in their book, Online Dispute Resolution, back in 2001. And the idea is that party 1 and party 2 are the disputants. Party 3 is the human neutral, maybe a mediator or an arbitrator or a coach or an ombudsperson. But technology is the fourth party. And many people ask me, is artificial intelligence going to replace mediators? And I say, no. The role of the third party is very important, and human engagement with the psychological needs of the parties is essential. Artificial intelligence is becoming more capable all the time, but you should think of AI and technology as your partner in resolutions if you are a third party. It can help you solve administrative challenges. It can bring efficiency to your process, and it is becoming more capable all the time. And the ethical rules that the fourth party must abide by are different than the ethical rules for the third party. Now, many of us know the big LLM, large language model AI platforms created by companies like Microsoft, Google, and Amazon. ChatGPT is associated with Microsoft, Gemini is associated with Google, and Claude is associated with Amazon. There are billions and billions of dollars that are going into these programs to make them smarter and smarter. And they are continually releasing new versions of their platforms that can provide better answers. I myself am very interested in the open source AI models. And instead of having to pay Google or Microsoft or Amazon, you can download these models yourself from a website called Hugging Face, and you can run them on your local computer or on your own server. Meta, which is the parent company of Facebook, has just released a new open source Llama 3.1 model that many think is just as powerful as the models you have to pay to get access to through Microsoft and Amazon. So it is very exciting to see how much innovation is occurring in this space. And I urge you, particularly if you have a friend who is nerdy and knows how to use technology, to experiment and play with some of these mechanisms. One other thing that I will point out is we are getting better at training LLMs with our own data. So you don't have to just use ChatGPT the way it's provided out of the box from OpenAI. You can now train it with your own information about mediation, about best practices, about ethical guidelines. So there are many ways that these technologies can be helpful as a fourth party in making mediation for consumers more effective. For instance, summarizing lots of information like documents or email exchanges, creating a timeline, helping parties understand what kind of case they have as they describe it in natural language and describing what a likely resolution might be. AI is very good at generating documents. So generating settlement agreements that can be edited by the parties and potentially filed with a court. Using AI to assign panelists to cases. So an AI can read thousands and thousands of bios of mediators and then say, for this particular case, this mediator is a great fit. And that's very hard for human panel managers to do. Also, tone monitoring to nudge the parties in the direction of resolution and avoid the threats and insults that can escalate cases and move them away from solutions. So the idea of an AI mediator or an AI arbitrator, we are working on that very hard at ODR.com and at the American Arbitration Association. But I still believe that technology that could replace a human mediator or arbitrator is at least 10 years away. But the technology that AI can provide to assist a human mediator or arbitrator is here today. The other thing I would like to point out is there is a risk of bias in the use of algorithms in resolving disputes. A computer or an algorithm doesn't necessarily have an agenda, but the person that programs that computer or algorithm can take their opinions and put them into the algorithm. And we have a lot of people doing research in the United States now about how we can de-bias these algorithms and make them more neutral and more impartial and more fair. So these are two very good books, Weapons of Math Destruction and Automating Inequality. But we have created an organization called ICODER, the International Council for Online Dispute Resolution, that has standards around the use of technology in dispute resolution. And we specifically address the use of artificial intelligence in dispute resolution processes and suggest best practices for how the risk of bias in the use of these platforms can be minimized. The other thing I will say, and ICODER is not the only organization thinking about this, we have great ethical standards for third parties, for humans acting as mediators and arbitrators. But we also now need to create ethical standards for the people who are programming these algorithms, because there is a real potential for abuse that the parties will not necessarily be able to see when they are participating in these particular software programs. So ethics and transparency and auditing for the tools that we utilize in dispute resolution is going to become more important as we move forward. So I actually am excited about the promise and potential of the fourth party in mediation for consumers. We see around the world a chronic lack of access for consumers. It's too hard and too expensive for consumers to get access to fast and fair resolutions. And through the use of technology, we can lower the barriers to access and provide services to our parties on a much greater scale. We can do automatic translation. We can do even voice-based prompts for people who may have difficulty dealing with text-based information. Artificial intelligence and the fourth party gives us the potential of tapping in to these new tools to expand the reach of the services we provide. And I think that's very exciting. We need to be cognizant of the risks, and we need to constantly work together to minimize them. But I think the opportunities outweigh the risk. And in 5 to 10 years, AI will be commonplace in dispute resolution in many areas around the world. So I will leave it there. Thank you very much.
Щиро дякуємо вам, Колін, за вашу
Thank you so much,
цікаву
Colin, for
презентацію,
this
за ваше
fabulous
бачення того, як
presentation
буде
and for
розвиватися
sharing your vision about
медіація
how
і в
mediation
онлайн-вирішенні
may and
спорів,
will
в
evolve,
тому числі
especially in the view
споживчих
of
спорів.
ODR
І
for consumer
прошу
disputes.
наших глядачів
So please, I'm
задавати
going to
запитання
encourage
для
our
пана Коліна.
participants to ask questions to Mr. Rule, please.
Всім потрібно
I think everybody wants to
продумати,
digest
хто
this
бачив
information.
підняти.
Oh, I can see
Прошу
one
вас,
raised
Ольга.
hand. Please, Olga.
Hello, thanks
Hello,
for your
Olga.
presentation. Colin, I want to ask you, which tools can you recommend, I mean AI tools, to use in mediators activity?
I will say personally, I use Claude and I use ChatGPT. But you must be very careful when you use these tools to not put any personally identifiable information into your queries. So it's fine to ask ChatGPT for ideas about how a dispute could be resolved, but don't include the names of your parties or any specifics about the disputes, because those submissions are put into the training data set for ChatGPT. I will also say, when you pay for a subscription at ChatGPT, you get the right to create private GPTs. And this means you can create your own LLM and train it with your information, what we call a RAG LLM, Retrieval Augmented Generation. So you can upload training materials for mediators. You can upload anonymized settlement agreements. You can upload lots of information that ChatGPT will analyze and learn from, so that the recommendations that it gives you are more informed. Many people talk about the risk of hallucinations with LLMs, and that is a big problem. If you ask an LLM a question that it doesn't know the answer to, it may make up an answer that sounds credible but is wrong. But RAG LLMs, when you can train the LLM with your own information, it significantly reduces the risk of hallucinations. So I highly encourage everyone. They are free. ChatGPT 3.5 is free, and Claude's base model is also free, but you can pay to get a more powerful model as well. And I urge everyone to experiment with these tools.
Дякуємо, Колін.
Thank you so much,
Наступне
Colin.
запитання у
Our next question
Самуель.
is from
Прошу вас,
Samuel.
включіть
Please,
мікрофон.
Samuel. Turn on your mic.
Hi, Samuel. I thought I saw Samuel unmuted. Oh, there he is. Now he's
Yes,
great.
hello.
I can hear you.
All right. Good evening, good afternoon, good morning to all the people across the group. Thank you very much for the opportunity given. I would like to first of all thank all the speakers. They have really done well, and I really appreciate them all.
I agree.
My question now is, what are the dangers associated with the introduction of AI mediators? Won't it take away the jobs of the human mediators? So I want to know the dangers associated with the introduction of AI mediators.
Yes, great question,
Thank you
Samuel.
very much.
I do not believe that AI is going to replace human mediators. I think that AI is going to make us into superheroes. We will be able to do much more work and much higher quality work because we are assisted by AIs. But the humans are essential in the process of dispute resolution because the psychological journey of our parties is intimately tied to the success of our programs. It is not just about having a computer that can spit out the best answer to a dispute. That does not move the parties through the journey that they have to go through to achieve a satisfactory resolution. And I think the third party is going to be essential in that process. Now, I will say, Samuel, I think that mediators with AI are going to take away jobs from mediators without AI. And in that case, you're right. Mediators that don't evolve with the times may be left behind, and their parties will go to other mediators. But I do believe, again, utilizing these tools and building AI that works within the ethical guidelines we have for mediation, we are going to be able to help many more people get effective resolutions, and that's a good thing. So there are risks, no questions, my friend, but I think the opportunities outweigh the risks.
Дякуємо за вашу відповідь.
Thank you so much for your answers. Olga, did you have another question?
Будь ласка.
Yes, please go ahead.
Please.
Thank you so much. It's a pleasure to hear LLM instead of AI. And I want to ask you another question. How do you think should mediator say clients about using LLM techniques?
Yes, it's an excellent question, Olga. I will point out before my response, I put a link into the chat to a resource guide we have created at ODR around AI. And this is a publicly available resource guide with many links and many suggestions. Please feel free to contribute to it as well. But Olga, I agree. From an ethical perspective, the best practice is to ask your parties at the beginning of the mediation if they would be comfortable if an LLM was utilized in the mediation process. And if their answer is no, you should not use an LLM in any way connected to the mediation process. You can put this into your agreement to mediate. But if the parties say, yes, I am open to the use of LLMs or AI technology in the mediation, then you should be transparent about it. I do not think that the best thing to do is to give parties access to an LLM so they start interacting with the LLM. I think it's better for the third party, the mediator, to have access to an LLM because, as I say, there is a risk of hallucination. I think the third party should always monitor the output from the AI and decide what is appropriate to share with the parties. But Olga, you name a best practice that I agree with, which is asking at the beginning, and if the parties are not comfortable, you should not use artificial intelligence in the mediation at all.
Дякуємо. Можливо, ще є запитання?
Thank you. Any more questions,
У
please?
чаті пишуть неймовірні слова
There are
вдячності
so many
за
words
ваш
of
виступ,
gratitude
за
in the
вашу
chat. Thank you very
презентацію.
much for your presentation and for your
Впевнена,
answers.
багато хто
I'm
для
sure
себе
there are
отримав
many
нових
new
вражень,
ideas that people
інсайтів
have
і
because people were
з
impressed so
новими
much
знаннями
by
буде
this knowledge and
втілювати
expertise
їх
of
на
yours. I'm
практиці.
sure we will be thinking about it and we will have to digest all
Якщо
this
немає
information.
запитань,
Since there are no more
всі
questions, oh,
дякують.
people write,
Якщо
thank
немає
you, it was
запитань,
awesome.
пропоную
If there are no more
завершувати
questions, let us
прекрасну
start adjourning this panel discussion. It was a brilliant one on ADR in consumer disputes. I want to thank all our wonderful, outstanding speakers for joining us at this forum. I'm also grateful for the time that our participants have invested into our journey together, for being active in asking questions, and I'm sure you have been quite satisfied by our today's panel. I'd like to move back to Louisa, our moderator general. Thank you so much. This has been a very strong end of the day, and that's probably the most important part of the entire forum, because tomorrow we're going to have master classes. But concerning the main part of the forum, I'm sure we've done a very good job. I want to thank Andy, Margarita, Colin, Georgia, and of course, I want to thank our wonderful moderators who have done a great job. Actually, before we take a family picture, like we always do, I'm going to ask Olga to please share the background. You see this background? So everybody who wants to download it and use it later, please do so. I want to thank our entire team for making it possible, for making sure this forum is a success story. Let me show you those who are involved in organizing everything and taking care of so many different things. And I forgot to mention our great assistant, which is ChatGPT. My daughter calls him by name. He calls him Gregor, the ChatGPT. If not Gregor, then our preparation for the forum would be much more challenged. In our today's circumstances, we seek support from everywhere, and therefore we use artificial intelligence pretty much. The only thing, maybe it's not yet 10 years there, but we treat it as an assisting software. So this is your own personal assistant, which helps you do things faster. But like with any assistance, you're the one responsible for everything, to double check everything, to verify all the information. But for sure, this is a super efficient solution that improves our lives. I hope you managed to download our background that you can see behind me. It's such a nice background that all the speakers were speaking in front of. In order to install it, if you're using PCs, that's very easy. Where you have the video button in the lower bar, you can press it and choose this virtual background. So you have the list of those options. You choose the virtual background and install it behind yourselves. If your camera is on, you can see different backgrounds, and in between you can see the plus. You choose the plus and download the virtual background that was suggested in the chat. And while you're doing that, I really want to display something. That's our team. Normally, as we organize a forum like this, we always forget to mention all those people who invested so much effort and time into these organization and logisticals and housekeeping things. Excuse me, can't help crying. I'm just being very emotional, you know? I just cannot express enough how much grateful I am to all these people. They're the ones who made sure this forum has taken place and will continue to every year, I'm sure. I was hoping not to cry, but I couldn't help it. It's so emotional for me. Because we put together so many people. We invited so many greatest speakers. Thank you so much for joining us. I know how challenging it is to join us from so many different countries, from so many different time zones, and being in so many different circumstances, we still made it. I think this is one of the strongest events ever. This would never happen if not the entire team. If there are people who provided their photos, there are those who didn't, and we didn't know if they give their consent for us to display their pictures. But my special thanks goes to our humble interpreter. That's for the first time when instead of the original language, I always listen to interpretation.
Саме перекладачів. Олександре, Олеже, ви насправді неймовірні.
Alexander and Oleg, thank you very much. You're incredible. And we really want to make sure that we cooperate as smoothly as you guys do when you swap each other. I mean, when you hand over. This is great. We felt it's seamless and nothing but pleasure from listening to you. Oh, thanks. Wow. I want to say that this entire team is comprised of volunteers, our alumni and graduates, our associate professors, and all the other people who joined their efforts to have this forum successfully organized.
Фотографії три команди, які об'єднали зусилля для того, щоб
You can see there's 3 teams that have done a great job, I'm sure. So let's take a family picture now.
Соломія, у вас рука. Чи не рука? Давайте тоді
Solomia,
зараз
you have your raised hand. Let us now take a
потім ми
picture
залишимося,
first, and then
якщо що, ми ще якийсь час залишимося, якщо
we
будуть
can
якісь
stay
запитання,
for a little while in case we have
ще одну
questions.
хвилиночку, будь
Oh,
ласка.
there you go.
Ну вже давайте сфотографуємося. Перед тим, як вас
Yeah.
фотографують, натисніть на
Please
allow,
press
займіть
allow.
позицію.
It means you give your consent to be taken a picture
Я
of.
ще хочу показати ще раз, мабуть, сьогодні я вже декілька разів це робила, ще раз
I've done
хочу
this several
показати,
times,
що
and now let me show it to you again.
матеріали ви зможете знайти тут.
All the presentations and materials can be available in Padlet. After the forum, we're going to continue uploading even more, so please go to Padlet. And we would really encourage Colin to share his presentation. It will be stored here forever, so it's all going to be available for you at any time with all the pictures, with all the scripts, with all the recordings in both languages, both English and Ukrainian. So all this information is available about the speakers and the presentations with additional materials. And therefore, whenever you have any additional information or materials that you would like to share with us, please do so at any time of your convenience so that we can translate them timely into Ukrainian and upload them to this forum page. Please share them with us, and we're going to do it for you and for the entire community. Let us again take a picture of each other. I'm extremely happy and thankful to all of you.
Це я просто мала замовкнути, щоб себе сфотографувати. І
I just
сподіваюся, що
had to
ми
shut
ще
up
завтра
so that they can
зможемо
take a picture.
побачитися, провести
Hopefully
гарний
tomorrow we're going to
час.
see you all and spend some good
Зранку
time together.
майстер-клас стосовно того,
So in the
як
morning, we're going to have a
робити
masterclass on
презентації,
how to make PowerPoint presentations,
презентації для того,
how to
щоб
make them stronger,
не
even if you
перевантажувати
know how to
їх
do them.
інформацією, для того, щоб
Maybe not to
уникати
overload them
якісь
with
типові
redundant
помилки,
information,
для того,
maybe
щоб
to avoid
якісно
typical
комунікувати
mistakes.
про медіацію, це буде
To
практичний
communicate mediation
майстер-клас.
in a
Будь
better
ласка,
quality
підготуйте
manner,
те,
this
що
is
у
going to
вас
be a very
є.
instrumental
Це
masterclass.
буде
So
PowerPoint
make
або
sure you
інша
have PowerPoint installed on
аналогічна
your
програма.
computer or a similar
Для того, для
software
створення презентації. І
for
після
making
обіду
presentations.
будемо
And
малювати
after lunch,
це
we're gonna
зміни,
have
малювання. Це, знаєте, таке
another
мелодія,
masterclass.
гармонія.
It's going to
Ми
be
просто
drawing,
класно
a
можемо
drawing
провести час
masterclass.
спільно,
I'm sure this is going to be
і
fun, and we're going to spend
на
great time
позитивному
together.
підйомі завершити
And
цей
then we're going to adjourn the entire forum at with such a nice and
Звичайно,
creative
всім дякую.
masterclass.
Завтра
I want to
зустрічаємося
express my
тим
sincere
самим
gratitude to
способом.
everybody. We are meeting tomorrow following the same link